The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning. Welcome to the Kansas Supreme Court's docket. We're excited to have all of you here. We do have a visiting group of students today. Ms. Jacobson, would you mind coming forward and introducing your group? Yes, if you would. We'd love to capture you on our recording.
Good morning. May it please the court, Chief Justice. I'm Connie Jacobson, along with Mr. Nurbass. We are bringing some U.S. government students, seniors from Topeka West High School, which is the alma mater of Justice Rosen.
And
I'm sure he's going to.
yeah, well, no, I just wanted to say welcome back,
Thank you.
Ms.
Yeah,
Jacobson.
Yeah, this is our
And
first.
to let
COVID
some of our new members of the court, Ms.
Yes.
Jacobson and her government class has been coming to the court and bring for the last 10 years.
At
I think we
least.
started that 10 years ago, and at least once a year, maybe twice a year, they come in the fall and the spring to experience the workings of the court. And she coordinates this with the study of the judicial branch in her government class. And Connie, you've noticed there's been some redecorating since the last time you
It
were
looks
here.
lovely.
This has been a 3-year break.
Yes.
And I just wanted to add to the decorum and the mystique of this courtroom by presenting this.
Oh, awesome. Awesome. Our Charger banner. Thank you. Thank
There
you so
you
much.
go.
Thank you. Thank you.
I'm never going to live this down with my colleagues, at least certain colleagues. But I thought, don't you think it complements
Yes.
the
perfect
beauty
colors.
of this
Yeah,
courtroom?
yes,
And
absolutely.
yeah,
I think most of your colleagues can't see it. I think.
well,
that
I'm
might be
sorry.
the only why.
If you'd like to
They
leave
can
the
see
bench
it.
and come around, it's a beautiful sight. I think it's going to be.
We'll have to do an inspection.
Probably
at
be
the
broadcast
Yeah.
on the news.
So we had our 50th plus one high school reunion a couple of weeks ago, and these banners were around. So I thought I'd take one for this very occasion. So
But we plan
there
on
you
coming
go.
back. So hang on.
I'm sure he took it with permission.
Well, maybe not. I didn't seek permission here. So it's kind of like anyway. Welcome and welcome, Chargers. It's good to have you here and have a good experience. Hopefully I'll be able to talk to you during break when you're getting your tour.
Thank you. Thank you for your hospitality. Thank you.
We
And
do
I don't
welcome
think that-
all of you, so.
I don't think probably during official argument, this shouldn't kind of appear. So I'm going to roll it back up, but just wanted you to have it. Thank you. And welcome again.
I don't know, we might spark all of us bringing in our high school.
There we go. I was going to nail this in, but then Mr. Valdivia didn't think that was such a.
Oh,
good-
now,
Here it is.
now we
There you
can all
go.
see it. Yeah,
See there?
it's very nice.
Very nice.
All right. Sorry, Chief.
That's fine. No, we appreciate the.
Yeah.
But we will turn to business, I guess. So at this point, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 o'clock docket.
First case on the 9 a.m. docket for Tuesday, October 25th, 2022 is appeal number 122229, State of Kansas versus Jose Elizar Portillo-Ventura, Hamilton County, briefs both sides.
Good morning. May it please the court. The state appears by Jody Lipfin, present and ready for argument, and fellow Charger alumni for what it's worth.
Is that right?
Okay, Mr. Call, there's no favoritism. So,
Topeka West, class 85.
okay. Issue here.
Hello.
That,
May it please the court, Corey Call, appellate defender representing Mr. Portillo-Ventura, present, ready for argument.
I'm gonna be a little sad if we break into a Charger chant here in a few minutes, but yeah.
well, enlightening arguments, I'm sure.
Second case on the docket is appeal number 122810, Kelly Rowe versus Phillips County Hospital, Phillips County, briefs both sides.
May it please the court, representing the plaintiff and appellant in this case, Kelly Rowe. Name is Max Couch.
present and ready for argument.
May it please the court, Quentin Templeton on behalf of Phillips County Hospital, present, ready for argument.
Your Honor, that concludes the 9 a.m. docket.
Thank you, Mr. Shima. Just a couple of words of explanation for those who are visiting today, as well as those who are watching on our YouTube channel, who we welcome as well. Just to explain a little bit of what happens before we get into the courtroom. The parties have filed briefs in this matter, which the court has read. In addition, we have received the record of proceedings that occurred at the trial court level, which we call in Kansas district courts. We have reviewed portions or all of that district court record. We have also received independent research from our own staff, reviewing the arguments of the parties, and have done our own study of case law and statutes or other things that may impact the cases that we are hearing today. We will ask questions throughout. That's a way in which we can better understand the arguments that the parties have made. In doing that, we may be glancing at our computers, we're looking at our own notes, or we may be looking at cases that they are talking about, statutes that they're citing, or looking at a portion of the record. All of that's done to assist us in understanding and processing the arguments that the parties are making. So when we are doing that, we are not distracted. We are actually actively listening in that way because it does help us with our comprehension of the case. And with that, I will now call 122229 and ask the council to please come forward.
Morning, and may it please the court. Again, this state appears by Jody Litfin this morning, and Your Honor, may I please request 2 minutes for rebuttal time?
Brandon.
Just a short summary as to how this case got before the court this morning. This was a criminal case where the defendant was convicted of rape, 2 counts of aggravated indecent liberties with a child, and an attempted aggravated indecent liberties with a child. There were 2 victims in this case. I'll use their initials, PF and CV. I believe PF at the time was 13 years old and CV was the defendant's stepdaughter and was 10 years old. At trial, both of them testified as to the touchings and to the rape charge, and the jury ultimately convicted on those 3 counts. There was also an issue, a stipulation entered into where the defendant stipulated as part of the one element of the rape, and I think of the ag indecent liberties with the child charge, he stipulated that he was over 18 years old. So there was a stipulation that was agreed to by the parties and submitted to the court, and the jury heard the stipulation where the state would have presented evidence that he was 18 years old. But I'm not entirely sure from the record, for whatever reason, defense counsel thought that would be more prejudicial for the state to present that evidence. So the stipulation was entered into and presented to the jury. The original briefs in this case were argued before the Court of Appeals, and there were 3 issues there. First being prosecutorial error in opening statement and in closing argument, the stipulation issue about having to have a full required jury trial waiver for the stipulation of that one element, and then a sentencing issue, which I believe the parties agreed was an error and the state didn't contest that there was a sentencing issue. So the Court of Appeals, in their opinion, found that the opening statement prosecutorial error claim, that was prosecutorial error and reversible error, and the jury trial waiver issue for the stipulation was also reversible error. The state petitioned for review to this court on those 2 issues, and the defendant filed a cross petition on the other issues of prosecutorial error in closing argument. I think that sums up how we got here today. So my plan was just to kind of go in order for issues 1 and 2, the prosecutorial error and opening statement, and then get to the jury trial waiver issue. So the statement that was found to be prosecutorial error in the court at the Court of Appeals was made in the middle of opening statement, and it was a sentence that stated, "I will tell you right now, I believe this witness." It was in the middle of sort of a paragraph, and like I said, in the middle of opening statement. And of course, the case law tells us that prosecutors can't offer their personal opinion about the credibility of a witness, and on its own, that sentence certainly taken in isolation does.
Well, not only in isolation, how is it even in context, not an error?
And I realize I've got an uphill battle here, but I would ask the court to look at the entirety of opening statement. Specifically, the use of "I believe" or "I think" in the prosecutor's entire opening. I actually spoke to the prosecutor, and he said he kind of used that language he thought here as cautionary language, as "I think she's going to testify to this, I believe she's going to say this," but you
I
know.
will tell you right now, I believe this witness. That's different. And I reread the opening statement several times. He does use "I believe" a lot. And sometimes that "I believe" skirts what is allowed also. But this direct statement, how is that not error, just flat out on its face?
Again, I would point the court just to look at the entirety of opening statement. And I do realize that that statement on its own is problematic. But also, as the Court of Appeal noted in our brief, we did, and I suppose I am asking the court to speculate, but we did note, and so did the Court of Appeals, that this was a sentence that was awkward. It doesn't entirely make sense as written, at least in my view, or the state's view, as to the other sentences around it. So I'm not sure if it was given with that exact punctuation that, you know, "I will tell you right now, I believe this witness," because it seems unreasonable to the state, at least in our view, that you would stop this. We believe the rest of the context of opening statement is okay. He's talking about what the girls are going to testify to. He's talking about the evidence. He's talking about the order in which the touchings happen and how there could be some, you know, issues on what each victim remembers in the order. And then he just stops that entirely appropriate summation of the evidence and says, "I'll tell you right now, I believe this witness." And that's just an unreasonable reading. And I understand we have the cold record to look at, but we think it's just an unreasonable reading that he would just stop that entire opening statement.
You're not
to say
saying it's
that.
an unreasonable reading. You're saying it's a transcription error.
I'm saying I can't prove it's a transcription error, Your Honor, because we did go back and look for the recording. Apparently this trial was recorded, and I asked the prosecutor to find that recording, and we couldn't. So I can't say I don't have any evidence to prove it's a transcription error, but there are other smaller errors in the transcription,
Okay,
missing
but you're
words.
saying it's an unreasonable reading. I don't understand I mean, are you calling it an unreasonable reading of the words on the paper, or are you calling it a speculative transcription error?
Well, I don't know that I can call it a transcription error because I don't have any evidence.
How can you call it an unreasonable reading when the words on the paper?
Well, I'm just asking this court to look at it in context of the entire opening statement and to think about a prosecutor talking about what he believes or thinks the evidence is going to be, and then stopping mid-sentence and saying for one of the victims and only one of the victims that he personally believes what their testimony is going to be.
Well, what's the alternative? Are you saying he did not say those words?
I can't say that he didn't say those words. They're on the record.
I guess, I mean, that's the same question Justice Standards is asking then. You can't say he didn't say those words, then you're stuck with those words. And
Correct.
it doesn't matter. None of the context matters. He said what he said.
Well, I would disagree that none of the context matters. I think you would have to imagine.
How does the context change the meaning of "I believe this witness"?
If you look at the other uses of when he said "I believe" or "I think."
Well, what's a plausible alternative reading of those words? Can you offer any plausible alternative?
I just don't know if that's where I don't know if that's where the period goes in this sentence. I mean, I don't really have a way for it to make sense.
Well, you've already acknowledged that you're on an uphill climb.
Yes.
This is a stretch argument. But you have to at least come up with a plausible alternative, don't you?
And I would go back to, I think what I put in my brief is, I think he was saying something along the lines of, "I believe this witness, which is first, second, and third, The only one I think she'll be certain about is the kitchen incident. So I think he was just going to the timing of the incidents and what CV would remember. And somehow it just, I mean, that's really the best I can do, is to say somehow in the context of this, he was saying, I believe maybe she won't know which one's first, second, or third, but she's confident on the kitchen incident.
You're saying that the words, I believe this witness, in the prosecutor's mind were supposed to be followed by different words, and then he sort of lost his train of thought.
I mean, or yes, or it was just something, I'll tell you right now, I believe this witness, and then he paused as to which is first, second, and third may not know, or, something like that. So I don't know that it was a declarative. And I understand, like I said, that's what's on the page, that's what's on the cold record. And if this court reads it that way, that's what it is. But I just don't know if I agree that in the entire context of what he was doing, he says, I will tell you right now, I believe this witness, stop, aside. I believe this witness, moving on to, a summation of the evidence as it was.
Let me move you over to harmless error.
Sure.
And one of the argument, and I guess two of the arguments you make, and I'll tell you right now, I think they're bad arguments.
Okay. As I'm used to up here, as I've heard before.
I'm just showing you can drop a rhetorical parenthetical into a sentence and tell you what I think, which is what I think the prosecutor did on the error side. But I do want to talk about harmless error. You make the argument that the seriousness of this error is diminished by the fact that the defense attorney didn't object and the district court judge didn't stop everything and go forward. And I thought we kind of killed that argument, those two arguments in Chandler. Why are they back here? I guess it is the Halloween season, but why are these two arguments back here, quite honestly?
My response to that, I guess, would be, in speaking with, again, with the prosecutor, if it was such a blatant and explicit personal opinion, and it was the way that the cold record says, I would expect that there would be an objection drawn. I mean, the way that reads is it's a violation and it's a prosecutorial error if that sentence is what it is. And the fact that didn't happen, I think that's worth something. I do. I think that means something, because there are two other people, the judge and defense counsel, who should be looking for these types of things. And I know you don't have to object for it to be preserved, but just that kind of a blatant, explicit error, I think it is worth something that no one said anything. So was it heard in that manner, I guess?
The only case you cite to support that, because you don't have anything since Sherman or since Chandler, where again, I thought we killed these, but the only case you cite is a pre-Sherman argument. And that case specifically said that the issue was not the prosecutor vouching for the credibility of the witness. So that case doesn't seem to be applicable to the argument you're trying to resurrect. So, I mean, where are we with this?
I mean, I didn't go back and look at that case specifically, but if that's all I have, then I don't know that I can point the court to anything else.
Can I, and then I want to hear your position on the closing argument. The Court of Appeals found that it was not error, but the statement, and it's prefaced, but we know the defendant is guilty because the evidence showed you that the truth was spoken. And the only spoken words were from the two young victims. There wasn't any corroborating evidence, that sometimes not, exist in these cases. Why isn't that just kind of akin to the prosecutor saying, I know she was guilty because the girl spoke the truth? I mean, it seems to me that's what it is, but explain to me why that isn't that.
And thinking back in what I wrote in the brief initially, I believe it was just because of the context in which it was said, and that he was, that the prosecutor was talking about the evidence that was presented, talking about their testimony. And as long as it's within that context, to say, hey, I think you heard the truth. Here's what they said. Here was the evidence, tying it back to the evidence.
And
I
you,
think,
I mean, you just said, I think you heard the truth. Wouldn't that be an erroneous statement from a prosecutor to make?
if I wasn't tying it back to what testimony there was,
Obviously, you're tying it back to testimony. If you're saying about you heard, I mean, the only thing the jury hears is testimony. But it's I think you heard the truth. That's a vouching for the credibility of the state's witnesses, is it not?
I mean, yes, but we get into such, the way that people speak and say, I think, and, you know, all of that we've talked about before. So, I mean, I guess, yes, but
Well,
tying
prosecutors
it back to
have a high duty
yes.
to provide a fair trial when someone's liberty is at stake. And so just saying, well, that's the way people talk. I mean, we have had decades of case law instructing prosecutors as to how they should talk. Doesn't strike me that that's going to win much favor, I guess. in an
I
appellate
would agree.
argument.
I mean, the most I guess I can point the court back to is context, tying it back to the evidence, because I think there can be situations where they're not talking about the evidence. And it is more emphasized than what it was in this case.
So my last question, just, I know you're out of time. If you'll presume with me that both of these statements are error, I guess I want to follow up on Justice Biles on questions on harmlessness. In a case where there's a lot of, say, physical evidence or something like that, I can see an argument maybe against harmlessness. But here, would you agree that the outcome of this trial hinged on a credibility determination of the witnesses?
Yes, we had testimony from the girls and then their forensic interview.
And that was it?
And yeah, an ID from a lineup, and I think that was all. Yes.
Given your time, I'd like to jump to Johnson and keep jumping over a lot of things in that issue and that discussion to a question of whether it can be harmless error and look at that jumping over the US Constitution to get to the Kansas Constitution and ask, how do we treat or do we treat this issue any difference from a harmless error standpoint, given the Kansas Constitution statement that a right to a jury trial is inviolate? Can it be harmless error, or is it structural error given that wording of the Kansas Constitution?
I hadn't thought about it specifically for Kansas Constitution, Your Honor, but I mean, I think I would still argue that yes, harmless error could apply, because in other situations where I think I could use the same analogous situations where we're talking about the omission of an element in the crime, and we still can do a harmless error analysis for that situation, which I would find pretty similar to what we have here. So I don't know that it would be any different under the Kansas Constitution than the United States Constitution.
Or type analysis, which we have done.
Yes.
Go ahead.
Can you remind me from the record, was that element included in the instructions to the jury?
I tried to look for that last night and I didn't have the jury instructions. I think it was, but I did not have the record to look at that, but I don't think they took it out. I can be corrected, but I'm not sure.
And do you think that's relevant to the constitutional analysis?
That it was left in, yeah, I mean, I think it shows that the jury still had to make the determination of that element and consider the stipulation with making that determination.
How does a jury reject a stipulation? How would that happen? I mean, you say the jury can still consider it, but how does it reject stipulation by both parties that this is the evidence that will suffice beyond a reasonable? I don't understand how that's a consideration that the jury still has to weigh.
I mean, I think if it's an element of the crime listed in the instructions and they were presumed that they follow the instructions and they consider that, they might not consider that stipulation. I mean, I guess if they didn't, then
they could not consider it and say you didn't prove he was over 18.
I suppose. I mean,
if a stipulation like that requires a jury trial waiver, would a jury trial waiver be required every time a defendant does not contest one element? I mean, it happens all the time. The defense says to the jury, we're not claiming that there wasn't a death here, for example. We're just saying we're not criminally liable for whatever reason. Would that require I mean, under the logic of the argument, it strikes me that we're going to have jury trial waivers all over the place.
I mean, I think that would be, yes, problematic. The stipulation though is, it almost seems a step further to me than just not contesting, because you're giving the jury some other, I don't want to call it a piece of evidence, but you're telling them about the stipulation, which removes the evidence. But yes, I mean, I think that could be going down that path, certainly. Problematic, and a lot more jury trial waivers would have to happen. And just to remind the court, he got a jury, I mean, we're at a jury trial. He had a jury trial, so.
So would you have to rely on jury nullification then? To get,
I mean, the jury could, certainly.
have to rely on that though. Does it satisfy the Kansas Constitution for that reason only?
I'm not entirely sure. I don't know.
Oh,
May it please the court. I'll answer any questions that you have. It seemed like on the procedural error, I think you covered most, but I think is important on that. As I said, I'll certainly answer any questions about that. I guess one thing I did want to address was on the opening statement. The state argued that because it was in the opening, it was less prejudicial. And I think where I disagree with the state is I think that assumes that credibility determinations are made in closing argument, or I'm sorry, are made in deliberations. And I don't think that's true. I think the jury makes a credibility determination while the witness is testifying. And so if you have the prosecutor in opening statement saying, I'll tell you right now, I believe this witness, then when that witness comes to testify, the jury has that in their mind. When they're evaluating the story, when they're hearing that testimony, they have that in their mind. And so the subsequent instruction of the court that it's up to you to make credibility determinations has less effect. And in any event, I don't think the problem here, and that was one of the harmless error factors, is whether the jury was told that they get to make credibility determinations. And while that's important, I don't think that's the real harm here, is that the jury, if the prosecutor says, I'll tell you, I believe this witness, that the jury is going to believe, oh, we don't have to make the determinations. The prosecutor did that. The fear is that the prosecutor, a respected member of the community, saying, I believe this witness, that is going to influence the jury when they make their own credibility determinations.
I was wondering if we shouldn't, I don't know, when I read the statement, and I probably have read it, it seemed to me that the prosecutor had just said, well, there are a series of incidents, and he was talking about one of the two girls. One girl doesn't remember really a couple of these incidents, but she does remember this, I think it was the second count. Yeah. And that's when he says, and I'll tell you, I believe her. I wonder if that his statement, which is a statement to make, touches the third rail, doesn't get muddled enough by the time you get to the end of the trial, presentation of evidence, to make an argument that it was really harmless in this case. So how would you respond to that?
I think, one, as he's talking about the witness, the jury, I think, would be very interested in This is new information. They're trying to figure out this witness. And so I think, I believe this witness, I think that would jump out while they're talking. But more importantly than that, I think the prosecutor prefacing this with, I'll tell you right now, I believe this witness. To me, that's an attention grabber. That you're focusing, if the jury is, it's opening, this wasn't a long trial and it wasn't a long opening, but to say, I'll tell you right now, well, that grabs your attention and that focuses the jury on that. And so I think it's less likely to be muddled. And the thing is that, as I said before, it was a short trial. And as when she testified, that they would remember that this was, it filtered their perception of her testimony. And so even if you get to the end, they may not remember that he said, I believe this witness, but it filtered how they considered her testimony.
Let me push back just a little bit
Yeah.
on that. It's because of the convictions. So the prosecutor, if you take my reading of this, prosecutor's definitely putting his thumb on the scale on count 2. So I believe this witness about this, but they convicted defendant of both girls and on multiple counts beyond just the count that the prosecutor commented on. And so again, why doesn't that tell us that the impact of this statement is watered down quite a bit?
Well, I think that even if you interpret, I'll tell you right now, I believe this witness, even if there is sort of a parenthetical on this incident, even if you add that in, which is not there, I believe this witness, even if you add that in there, the incidents are not so distinct, are not so different factually, they're not so different contextually that you would think, well, this, if you believe that that incident happened, the other incidents seem similar to that. And I hate to make problems for myself, but I've got, as to that incident, I have a bit of a problem because he only talked about one witness, right? And he didn't say he believed PF. He said he believed CV. And the state would argue in harmless that, well, CV, the one who he's talking about, her testimony was bolstered by PF's testimony. And I would argue that because these incidents seem factually similar to each other, that the taint of that comment spreads over all of them. So my answer is that I'm not sure that when a jury is listening to testimony, is listening to a witness, that they compartmentalize each incident as far as, okay, I believe this incident, I believe that incident, I believe this witness. She said this, unless there's something, entirely different about different place, a different context, a different alibi, a different something, which isn't the case here. It was a total denial, total accusation. And so I guess I don't think that, to me, if I understand your question right, that the allegations would have to be somewhat compartmentalized to believe, well, this incident, to believe that a statement that I believe that this incident happened didn't taint all of the allegations.
Mr. Call, I'm gonna take a little bit from what Justice Biles said. Going into this, I kind of had a perception of what the transcription error argument was, but Ms. Littman kind of narrowed that for me. When you're looking at, or when I'm looking at the comment and taking it in context, it does kind of seem like not a transcription error, that maybe the transcriptionist wrote down the wrong thing, but what the cadence of when you're talking and when there's maybe an ellipses, when you're pausing, or what does happen, because they do kind of seem like they're not complete sentence. The second incident occurs, comma, or at least we think it's the second incident in time period. I will tell you right now, I believe this witness, period. And then it starts with, which is first, second, and third. The only one I think she will be certain about is the kitchen incident. But it almost seems like there's, as Justice Biles was saying, that you're talking about 3 incidents, and it seems like maybe what the comment is that she's not certain about the first or third, and that he's really focusing on, the second incident. He's kind of saying, look, maybe the first and third didn't even happen. And that he's focusing on the third. But what my bottom line is, what do we do with the fact that a cold transcript where a transcriptionist decides where the punctuation goes? What do we do with that? Because really, basically, we're talking about this sentence, which the transcriptionist decided to put in here with a period, as a separate sentence, with a period, that we're all up here saying, I will tell you right now, I believe this witness. And we're looking at it as an isolated sentence that we are considering overturning an entire conviction, lots of convictions, and granting a new trial. What do we do with the fact that this could just be the transcriptionist setting apart those words and putting it in a sentence?
I think what you do, to answer your question, frankly, is as it's written. I think we deal with, undoubtedly, transcriptionists and court reporters, they're not perfect. They make mistakes. And it is difficult for us on appeal to know where those mistakes are. But it is perhaps one of the fictions that we live with, that this is what happened. And we can recreate the record if we can. But if we can't, this is what happened. This is the history. This is what was written. And I think maybe sometimes there are obvious errors that maybe point out that maybe we can say, well, this appears to be an error. But even then, I think the remedy is to go back and you have a fact finder determine, is this what happened? And if they can't do it, I think this is the default. I think there has to be, you have to have something that says this isn't what happened. And I'm not sure this court is the one to do it. I would also point out that I think, again, I will tell you right now seems to me to be a conversational aside. It's almost something you say when you're stepping out of a train of thought. So the second it occurs, at least we think it's second. I'll tell you right now, I believe this witness. Then which is first, second, third, she doesn't know. And so I don't read it as confusingly as the state did. Although when I was originally reading this and writing this, one of the problems I have is this is so bad of a statement that the inclination is, maybe this isn't right, because no one would say this, but here it is. And so, but to answer your question, this is the record that we have.
Thank you.
Can you help me? One of the things I struggle with in the prejudice analysis of our legal standard is the role of the instructions and the deference we give to the jury to follow those instructions. And if you read U.S. Supreme Court precedent, it's not one that we dispose of easily. It's a strong presumption. And I assume here the instructions, if followed, would have enabled the jury to set aside those remarks. But on the other hand, there are times where that presumption is set aside, and that the precedent from the United States Supreme Court suggests that there must be some sort of indication that there was more involved, that the jury was detracted from adhering to those instructions. I guess, how do we analyze the power or the force of the instructions, and when we do this prejudice analysis?
Well, I think, again, it's one of the fictions that we live in, that the jurors just follow everything. But we do step back from that some and say, well, this was too much. And I think the specific instruction that you're talking about is the instruction that it is up to the jury to make the credibility determinations. I believe that is the instruction. That's one that the state argued.
In the
Or arguments
statements of counsel
are not evidence.
Right. And so I think on that, just to get, that's my broad answer. That's about as good as I can get. Specifically in this case, as far as the statements are not evidence and anything, not evidence, so you should disregard. This isn't evidence. that we're talking about. This isn't if this had been where he had said that, oh, this happened in the kitchen and it happened in the bedroom, then that's a situation where, and we're arguing that's error. Then maybe the instruction that says, well, you should disregard what the prosecutor said, but that's not what we're talking about here. This isn't evidence. This was a comment on credibility. And as I said before, if the problem here, it says that it's up to you to make the credibility determinations. But I don't think that that cures the prosecutor statement that I believe them to, because the jurors can make their own credibility determination. They can say, I believe that, but they can be influenced by that. And I don't, it is difficult to see how a juror would not be, that their perception of the witness would not be clouded by a statement in opening, I believe this witness. And so I think you look at the totality of circumstances, you look at, my opinion is that you read the instructions narrowly in this regard. If the prosecutor makes an error, then you look at those instructions. What exactly did this instruction say? And I don't think the instructions here cure the error. And they certainly couldn't have done it, cure the error, because they weren't given until the end of, so they couldn't have been said before, if the instructions given before closing. I don't know if they have any effect on the statements in closing, but certainly not the ones in opening.
Real quickly, can we move to just the second issue? And
Yeah.
I kind of have an overall kind of global question that came to me as we were preparing for the case, is that it seems that under our case law, we require a jury trial waiver when a stipulation is being considered to one of the elements of the offense. That's kind of the Johnson case and its progeny. And just struck me, why do we require a waiver to a jury trial, to the very right that the defendant is exercising by going to jury trial? It just seems to me the inquiry of what was done here seems to satisfy part of the jury trial waiver, but the other doesn't. But the jury trial is happening. He's not waiving his right to a jury trial. So help me with that kind of quandary. It just seems strange to me that we're requiring a waiver to something he's exercising.
Yeah, as I understand it in reading, and I'm basing this mostly on Mason and Smith, which are the 10th Circuit federal cases, that a stipulation is not evidence itself. It is removing the element from the jury. It is considering that the element has been proven. So you're taking that element away from the jury, and a defendant has a right to have a jury find each and every element.
Why isn't that just evidence, though? Again, I go back to the question I asked opposing counsel. If part of the defense is, and defense lawyers do this all the time, we're not contesting, this element. We're not contesting that the victim was murdered, for example. And that's an element of the crime. And it's not a written stipulation, but its effect in the trial is identical, is it not?
It is, and
wouldn't Johnson, read strictly, wouldn't Johnson require a jury trial waiver for that kind of an argument?
Two things. One, I would say, you say jury trial waivers all the time like that's a bad thing. And I don't know that that is a bad thing, as far as that before the defense enters into some sort of guilt-based defense, which I think is what we're talking about here on an element or on an entire count, that the defendant is advised that he is doing this. I'm not sure that that's a bad thing. But as I read the federal cases, and I don't know how Kansas, we're still kind of discussing this, and it may come to that, but a stipulation is fundamentally different than evidence. And they talked about, I think it was the Smith case, talked about the jury nullification and the idea that if a stipulation is merely a piece of evidence, given that the jury is free to reject or accept, then the state should be able to bring in more evidence, right? If let's not use this, let's use a Johnson situation where there was a conviction for a gun. Well, if a jury can say they stipulated this, but I'm a show me kind of guy. I want to see that conviction. I want to see the conviction. well, should the state be able, because you stipulate, should the state be able to bring in the conviction and show it anyway, if the jury can reject that evidence? And the answer comes in the fact that stipulations aren't evidence. Stipulations are an agreement of the parties to remove that element from the consideration of the jury. The state no longer has to prove that element. And so the jury, there was one of the cases, I think it was Mason, was where the judge explicitly told the jury, you don't find these, you don't have to consider this. This has been proven. And the defendant said, whoa, that's a directed verdict on those elements. And the 10th Circuit said, no, the judge did not remove that element from the jury's consideration. The parties removed that element from the jury's consideration when they stipulated. And so I don't know if that's a difference, because I fear that I'm going to be up here arguing exactly what you're saying. But as I stand here now, that is the way the federal law is.
Under that scenario, it would matter, going back to Justice Wall's question earlier, it would matter whether or not the jury got an instruction on that element.
I don't think it would matter because I mean, I guess the
Well,
jury.
isn't that the polar opposite of the judge saying you don't have to consider this, is saying here's the instructions and you do have to consider this?
It is, but I would think that both could be proper, and just that we trust juries that if we say this element has been proven to you, then we trust that the jury is not going to nullify and go away from that. That's why we don't allow the state to present more evidence on the point.
And factually, was that element included in the instructions here?
I believe it was. I did not specifically look that up, but I perhaps am arrogant to think that I would have pointed that out if in my brief it had not been, but I believe that is the case.
Rise, Mr. Cole. All right, Ms. Litva.
May it please the court. I guess the only comment that I wrote down was just to remind the court that we did have two separate victims here, and only one comment went, or the comment in opening statement only went to CV, not to PF. And just to think about the way that their credibility was attacked during trial, and that, I mean, if we look at PF's allegations, her family and friends, I mean, she was called into a room with a bunch of adults and basically told she was lying and that she was going to go to hell for what she said. So I think if the jury can consider all of that and still find the witness to be credible, even when her own family and friends didn't believe her, that there was a large attack on her credibility. And I think that is important to point out when we're looking at the statement that was made towards just CV as opposed to PF.
Should we as appellate courts, and this includes the Court of Appeals as well, when they heard this, be asking the reversibility, the harmlessness reversibility question with respect to individual verdicts as opposed to just the verdicts? In other words, our appellate task is to determine the likelihood of the impact on the verdict. And this is an interesting case because it is maybe more clear than other cases that this particular error goes to the credibility of one witness. And so should we be asking the question, did this error impact the other convictions?
I mean, I think it's a case by case basis, and here, yes, you should.
But no, I'm asking, should we be asking that question, period? Obviously it's case by case, the answer to that question, but that's not typically how courts have handled the reversibility question.
I think, yes, that's true. And I think, yes, this court can be asking that question.
Did the Court of Appeals do that here?
No, I don't believe so.
It didn't. I mean, I would agree. It didn't appear
Yeah.
that they did.
I don't think that they considered that in.
Is that something that creates an error of law, do you think? In our appellate review standards?
Not consider, I mean, let me just make sure I understand what you're asking.
You've got
Not consider.
multiple different verdicts and you've got an error. And so then the question is that error reversible? And we're supposed to ask those standard questions. We all know what they are about its impact on the verdict. But I think that courts have not sort of split that out at the lower level of, okay, are we supposed to ask its impact on each separate conviction or just the conviction as a whole? I mean, the entire case.
I mean, I think,
Understand what I'm asking?
yes, I do. I mean, I think that's what I'm asking this court to do is, hey, take this into consideration in the analysis and how does it really affect the counts that only go to, you know, the other witness's testimony when there wasn't that comment, that same sort of
Do you know
personal
of,
opinion.
do you know of any case, and did you even look, and I haven't talked for any case in which some convictions were reversed for prosecutorial error, but others were not?
I did not look and I cannot think of one now, but I didn't look.
And just help me kind of procedurally, these were two separate cases charged, didn't they each with each victim having a different case number? Is that right?
I believe that's correct.
And then they were consolidated for trial. Was it treated as one case at trial or was it kind of separated out?
From my understanding, it was treated as one case
Okay.
at trial, which is why we get into the sticky sentencing issue because they were consolidated.
Yeah.
But yes, I think they began as two separate.
And that was consolidated. And then one last point you made in your I think last paragraph of your supplemental brief, you asked the court to, on the second issue, to, I believe, if I can paraphrase, send it back. It doesn't matter. We don't care if you send it back if we find error because we're okay sentencing this as if the defendant was under 18. I'm paraphrasing here, but is that what you're, and one, isn't that a little late to be asking for that relief? But is that your position here, is that if we find error on the second issue, the convictions still stand, but it would be sentenced as if it's an on-grid sentence?
Yes, I think that was my point in
All right.
pointing out that there was other case law where if there was no evidence that the defendant was 18 years or older at the time of the alleged crimes, that would be the remedy to go back and just put him on grid. Now there was a departure here where he is on grid currently. So again, that's kind of where he is at the moment, but yes.
And you would agree, no one's had a chance to address, counsel hasn't had a chance to address that.
I would say my supplemental brief is a lot more thorough than what I argued in the initial one, yes.
I was thinking about, I want to get back to the threshold question of error. It occurred to me when I was sitting up here, I remembered that I did a trial back in the day where I got a mistrial based on opposing counsel's openings. It strikes me that if a motion for mistrial had been made after this prosecutor's opening statement, I can't see that it would not have been sustained. And so that's affecting my consideration of that threshold. Where am I wrong in thinking that way?
Well, Your Honor, I'm trying to think of how I'm trying to think if there was a case where there was maybe an objection and the district court, or yeah, a motion for mistrial based on prosecutorial error. And the district court got to make some kind of finding as to, you know, the way that I'm trying to think of other cases where possibly there was an argument about tone or sarcasm or
It's not
something like that.
I mean, because the prosecutor injected something that we all know the prosecutor's not allowed to put into the room, which is his opinion of witness credibility. That's just absolutely the third rail. You touch it, you die. And I realize we can then talk about the impact of this later on as the trial unfolds. But I'm just thinking that from the context of if you'd have done a motion for mistrial at the beginning, it would have been sustained, which is to tell us that that's error. And I can't get off of that. So I'm giving you the chance to get me off of that.
Sure. I guess where I was going with that, and maybe this court, maybe you won't buy this, but where I was going is, I guess, if there was a motion for mistrial and there could have been other determinations by the district court, I mean, if we're just assuming that it was, you know, that one sentence on the page, cold record, yes, that's what we have to do here. But possibly below, there could have been more determinations made by the district court, like, oh, well, yes, he said those words, but like we were talking about the cadence or how it came in or other things like that, the district court could have said it wasn't just a standalone opinion or made some kind of facts about that. So I don't know that it would have just been, there could have been other determinations that the district court could have made, I guess.
Well, if an objection had occurred, the district court could have declared a mistrial, could have given an instruction to the jury to disregard what had just been said. It is inappropriate for counsel to comment on his own opinion unless he testifies. And so there are other things that could have been done at that moment.
I would agree,
I think
yes.
what you're trying to say is it could have been strategic that, okay, if assuming the defense counsel heard and realized the significance of that, which, you know, they've got a lot going on too. But if they strategically decided not to object, there's still a possibility of an acquittal. And with a statement like this, if there's a conviction, we've got a good chance of getting another try at it. So it could possibly be strategic, right?
Sure, yes, I would agree with that.
But I'd like you to address what your opponent said about the effect of a taint. Taint spreads. Yes, he was only talking about this one witness, but we've got a consolidated trial here. Same defendant. What is your best argument that a taint made by this statement about one witness shouldn't spread? How are we to analyze that?
I guess I would say that the opposite, I mean, because the prosecutor was vouching, let's say, for a CF, would the jury think the opposite, that he didn't believe, or I'm sorry, CV, that he didn't believe PS then? I mean, if that makes such an impact on what the jury believes, that the prosecutor is providing his personal opinion about one witness, would they assume that because he didn't give his personal opinion about the other witness, that the other witness is not believable?
But where do we put the needle? Where does the tie go? Does the tie go to the runner? Does the tie go to the prosecution? Does the tie go to the
Not
defense?
usually. I guess I would say that would go back to maybe my argument of where this occurred during the trial helps mitigate its effect, in that the evidence hadn't even been presented yet. The witnesses hadn't even been called to testify. So the prosecutor can say, I believe this, I'll tell you right now, I believe this witness, and the witness could get up there and the jury can look at her credibility and her body language and the way she testifies and the way that she's attacked on cross-examination and determine then if they believe her or not. And then they have all of the days of testimony, which this was a short trial. Then they also have the instructions that they're presumed to follow by the court as well, which properly stated the state's burden of proof and told the jury that statements of counsel are not, statements and arguments of counsel are not evidence. And then we had closing arguments where the prosecutor, I think both sides agreed that the prosecutor began his closing argument by telling the jury, this is up to you. It's your duty to decide whether these girls are telling the truth or not. And then ended his final closing with the same sort of comments, telling the jury that it was their duty to make those credibility determinations. So I guess I would say it doesn't spread, given that it's in the beginning of the trial and given what the jury has heard after that.
Thank you, Ms. Woodson. Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement. I will now call 122810 Kelly Rowe versus Phillips County Hospital. The parties are aware of this, but to let those who are watching our oral arguments today know that Justice Wall is recused. If you see, he's left the courtroom, and he will not participate in this argument, nor will he participate in the conferencing of the case or in making of it.
Thank you, Your Honors.
May it please the court. Max Couch of Couch Law LLC, on for Kelly Rowe, the plaintiff appellant in this matter. I would request 2 minutes to reserve 2 minutes for rebuttal. Your honors, the plaintiff in this case, my client, is asking you to find that under the KORA, the Kansas Open Records Act, a public agency is obligated to produce records in the format of the requester's choice, so long as the agency has the capability of producing the requested record in that format. Here, it is undisputed that the public agency is capable of producing the record in that format. So that factual issue is not an issue.
What if it's unduly burdensome for them, or they think it is?
Well, I don't think that the unduly burdensome argument was ever made necessarily, and that would require citation to a separate provision of the Open Records Act, which is 45-218E. That never happened here. And beyond that, the records that are requested in this case are Excel spreadsheets and PowerPoints that were shown at board meetings. So these documents, these records exist. It's just a matter of sending them out. There's no overly burdensome issue here in this case, Your Honor.
Well, I understand what your position is in this case, but your first statement was very broad, that they must provide it in the matter requested, regardless. So, is there a remedy if the agency believes that the requester's request of format is unduly burdensome, overly cumbersome for the agency?
Yes, Your Honor, they can cite KSA 45-218E, which was not cited in this case. And that is the statute that specifically refers to or empowers the agency to make that determination that it was unduly burdensome and deny the request on that basis. So I would amend my previous statement to the extent that if it is an overly burdensome request, then the agency would have that as a backstop under that specific provision.
Well, I just want to get the facts kind of cleared up, because honestly, this phrasing of, native electronic format, there are times when people have asked for data to be put into an Excel spreadsheet with certain data limiters, and that's not what's at issue here, right? These are already existing Excel files and PowerPoint files, and maybe a Microsoft Word file or two, or are we just talking about these two?
I think we're talking about Excel and PowerPoint.
Okay, so that's that, but they're already created by the agency and they're just sitting there.
That's correct. They are records that are existing, and the requester has not asked the agency to create records.
Let me ask you this though. Okay, so it's an Excel PowerPoint, and just based on my limited knowledge here, in Excel, all right, so they were presented in a public meeting,
Correct.
right? And that's why they're KORA. And so, but there's metadata in those little blocks of the Excel spreadsheet.
Right.
Now that metadata was or was not, or is not subject to an Open Records Act.
Well, it is subject to the Open Records Act because the definition of a public record is any recorded information regardless of form. And so once that metadata appears in an electronic record that the agency has created, then regardless of form, it's a public record.
So an Excel file that where some cells are actually formulas and not real numbers. If the agency produces that as a paper record, then the public would not know what the formula is that went into the calculation that created what is only a number on a piece of paper.
Correct, Your Honor.
That's the whole thing about native format, because then you get the calculations.
That's correct, John.
Is there an additional right under the open record, public records law that says that the person requesting the data after they get the Excel file could have the ability to process the data and the numbers, for example, to do statistical analysis, or even to just to simply take a cell or a column, I should say, and reorder it. So that, but for example, if you had an Excel spreadsheet with all of the all the state employees of Kansas and what they're paid a year, but it's done alphabetically, but what you care about is who are the most highly paid. If you get it as an Excel sheet, you can just click the column and reorder, as opposed to having to re-enter the data if you're operating off of the piece. Are you saying that you have the right to be able to get the document as it exists at the agency, but so that you can do that kind of process?
Absolutely, Your Honor. The determining factor is in what format does it exist in the agency's possession. And once it exists in that agency's possession, the Cora provides that those records, regardless of form, if they're not subject to any other provision for redaction or 45-21A, must be disclosed.
Counsel, isn't format a red herring in this case? We keep talking about format, but it strikes me that what we're actually talking about is whether this is a public record.
Well, I'd love to talk about just that, Your Honor. That'd be just fine.
So why is this entire case been framed through the lens of what format it has to be produced in? When, I mean, the real dispute here is, do we get the data?
Right.
And that question goes to, well, is this a public record? If the electronic version, I mean, if that is a public record subject to Cora, I guess I don't understand why we're arguing about format.
Well, I'm with you, Your Honor. I believe that this case is simpler than the arguments that have caused this case to come up to this level. And I think it really just comes down to KSA 45-217J1, which defines public record, which means any recorded, the statute word for word, public record means any recorded information, regardless of form, characteristics, or location, which is made, maintained, or kept by, or is in the possession of a public agency.
And you're saying, look, this electronic record, which we can shorthand as an Excel file, is a public record, and I want to see it.
That's exactly.
That's what you're saying.
That's exactly correct, Your Honor.
And so it sounds like you're agreeing with me that, well, what format it comes in is just an irrelevant red herring question. I mean,
I guess I have to push back against that, Your Honor. What I think and in order to do that, I think it's important to review there's another controlling statute that deals with electronic records, and that's KSA 45-221 A16A and B. And in my in the petition for review, I cited an Attorney General opinion that's 88-152. And that analysis, there is no reason to deviate from that analysis. That analysis is a liberal construction of the open records law. And the key piece is where it says in 45-221A16B, it says that the thrust of the statute is that software programs do not have to be disclosed. That's the thrust of the statute. But then it also says that the agency is required to provide to the public the form in which the information can be made available using existing computer programs.
Okay.
It's that can be made available sentence, that provision that is so crucial and caused the Attorney General in this opinion to write that the above quoted statute implies that a public agency must, upon request, make duplications of records in any format which it has the capability of producing. And that's the rule that was established and adopted for decades until the.
Let me just change my question slightly. It strikes me that if you quote, change the format, you've changed the record. I mean, it's a different public record at that point.
So I do agree with that, because in order to get the record that is actually in possession of the agency, that record is electronic, and we know that it is based on the facts in this case, then the open records law requires disclosure of that particular.
Yeah,
record.
it's just, you make a copy of it, you burn it on a CD or you put it on a thumb drive and that's that.
Or email it, yes.
And so I guess, yeah, I think you've answered my question. It just strikes me that this
Well,
is simple.
So the Court of Appeals was wrong when it determined the CORA allowed the responsibility of determining the method and the manner of reproduction to the public agency. It's really, is it the requesters that has the right to determine the manner and the form of it, or is it the agency? That's basically, and then they went to, well, the legislature hasn't amended it like other states and the federal government has to include electronic copies, or even say it's the requester's desire to whatever form it is. That hasn't happened here. So how do you respond to what the Court of Appeals did in this case?
Your
Because
Honor.
that's really what they held. It's just
Well,
the hospital gets to decide, not you. Yeah.
Well, the reality is though, is that this legislature already has decided, because under the Court of Appeals ruling, the provision under 221A16B would just not exist. How about what happens to can be made available using existing computer programs? What happens to that provision if the
Can be that, and that's up to the agency to decide. And so why is that wrong?
Well, at that point, then what we can do, if we feel that it's necessary, if there is an ambiguous provision, whether there is a fair interpretation, whether there are multiple interpretations that can be fairly made, that's when we have ambiguity.
Well, I'm sorry to interrupt, but real quick, why is 221A16 even relevant to this case?
Because it sets forth the implication that that electronic records.
No, it's talking about, I'm sorry, but it's talking about information. And again, to me, this is important, and I may be completely off track and you can correct me, but I have understood this dispute as a dispute over records.
Right.
Certainly records contain information, but you want a specific record that you allege is in the possession of the public agency.
Correct.
You're not looking for information that is in a computer system, which can be made available through certain formats and it seems to me that actually favors your opponent.
Well, I will say that
You're asking for is a record.
that's correct. And I think that I will go back to how I tried to answer your question first, Your Honor, which is that the simplest explanation for why the record is available is simply because of the definition of public record. And beyond that, and to try to get to your point about mandatory disclosure, well, we have to look at 45-218 for that. 45-218A says that the public is entitled to records absent an exception. Absent an exception.
But
No-
isn't it true? They're not objecting to you getting the record. They're objecting to the form in which you get it. And they're saying, we get to decide whether you get paper or you get a thumb drive. We get to decide that. And you can have the formula. We'll give you the formulas. We'll give you the copy of the spreadsheet on a piece of paper. We'll give you all of this information. But they're saying, we get to decide how we give it to you. And their basis for that is that the Freedom of Information Act specifically gave that right to the requester. And when our legislature wrote the Open Records Act, it left that out, implying that, now there's a dearth of information, but under one rule of statutory construction, there's significance to that. What's your best argument that doesn't simply mean that it is the agency's right to decide how we give you that record?
Well, Your Honor, the first of all, that language does not appear in the statute, of course, where the agency has the express authority to decide.
Right.
So neither of those express provisions are present.
But the previous one on which it was modeled, the Freedom of Information Act, did say the requester gets to decide.
Well, Your Honor, I'm going to push back on that too. The Kansas Open Records Act was modeled after the Kentucky Open Records Act. It was not modeled after the
It
Freedom of
also gave it to the
Information
requester, correct?
Act. I do not believe so. I don't, the Kentucky Open Records Act does not provide that to my knowledge. And that's what we have here is to the extent that if we're discussing whether or not the language has to be specifically in the statute or not, that creates ambiguity. And if we're going to go there, which I don't think we need to, because we have an open record or we have a public record, it's defined that way and it just needs to be disclosed. But if we are going to get into ambiguity, we don't have to search for the legislature's intent here. When there is ambiguity and the plain language could be interpreted different ways, we go to what the legislative intent is. And fortunately, under 45-216, we don't have to look. We know exactly what it is. And that is that the statute should be liberally construed and applied to promote the policy of openness. And so to the extent that this statute is ambiguous, the Attorney General opinions, these decades of opinions that with this well-reasoned analysis holds that ambiguity is resolved in favor of openness because that's what the legislature intended.
But they're giving you the information. Hey, we're wide open. You can have all of this information. We're just not going to give you a thumb drive.
Well, I mean, I'm going to go back to policy positions that I think are well stated in this original Attorney General's opinion. They cited a case from 1971. And that's it's from New Mexico Supreme Court, so certainly it's not binding, but I think this quote is incredibly instructive, given that we have courts back in 1971 and the Attorney General's office in 1988 restating this. We are unable to understand why the right to inspect public records should not carry with it the benefits arising from improved methods and techniques of recording and utilizing the information contained in the records, so long as proper safeguards are exercised to their use, inspection, and safety. That's exactly what we have here. And the public policy that underpins CORA necessitates the disclosure of the records. And if that record in possession of the agency is in electronic format, then it must be disclosed under the Kansas Open Records Act.
May it please the court. Good morning. My name is Quentin Templeton on behalf of Phillips County Hospital. Based on the plain language of the Kansas Open Records Act, excuse me, and this court's longstanding jurisprudence, this is not a close case. The Kansas Open Record Act does not contain a requester's right to dictate the form or the format that public records are produced. Justice Stiegel, I have to slightly disagree with some of your earlier questions. This isn't about whether or not they get access to the record. They can have the record, just as Justice Wilson was commenting.
Well, what is the record?
The
What is
record,
the public record at issue here.
well, there are a lot of them. After Ms. Rowe resigned from the Board of Trustees of Phillips County Hospital, she started sending multiple CORA requests to the hospital. There are Excel files she's asked for, there are PowerPoints, there are Word documents.
Why
There-
aren't those the records that are at issue?
Sure, those can be the records. The question is, what format does she receive those records in?
Well, but this gets to my fundamental conflict in this case. A record is a discrete thing. It's an object. It in the old-fashioned world, it was this. It was something on a piece of paper. With computers, it can be much more complex, but it's still a tangible thing. It's not data. It's not information. It's a thing. It's a container that holds information in it. And that's what the statute makes publicly available, is the record. And so I feel like the arguments constantly are blurring the lines between information, data, and the record. And when you talking about formats, you're talking about information. If you're changing formats, you're saying, I'll give you the information, but I want to give it to you in a different format. That's a change in the record. You've moved from one discrete object to another discrete object. It's like two cars. And I'm going to take what's in the trunk of my car and I'm going to put it in the trunk of this other car. But it strikes me that the statute, and this is a long-winded question, but it strikes me that the statute says, no, you got to give them the car. It's the record that's at issue.
And that's slightly incorrect. So Cora offers two basic rights. First is the right of inspection, and second, and it's a secondary right, is a right to abstracts or copies.
But aren't copies obtained for the purpose of inspection?
Presumably, sure.
Aren't you parsing that very, very finely?
No, actually not. If you look at the actual Cora as the legislature enacted it, they use inspection and copies very distinctly and in different ways, and they have different meanings.
So
And in-
are electronic copies different from hard copies?
I don't think so under Cora.
Well, why in 218, KSA 45-218, do they even refer to original copies?
The best answer I can offer is the fact that Cora was enacted in the early 1980s. I'll age myself, but it even predates
But
my
doesn't
birth,
that make
but
the word copies ambiguous?
no,
If
I
it can
don't.
be a hard copy, which is different from an electronic copy, which is different from an original copy?
I don't think so, because for an example, my daughter, excuse me, has a Van Gogh painting in her room, but it's not a real Van Gogh. It's a copy of a Van Gogh, right? It's been printed off of a printer, despite what she thinks, despite what I might prefer having an actual Van Gogh, she has a copy. Everyone knows what a copy is. It is, if we look at Black's Law Dictionary, we look at Merriam-Webster, which are cases that, or are sources that this court turns to for interpretation, it's just a reproduction of the original document, which gets to Justice Stiegel's question, which is, we're not talking about the actual document. A requester never gets an actual document to take home with them. Now, Cora does provide the opportunity for the government agency discretion to give the actual document to the person, but we're always dealing with a reproduction of the original, which always necessarily means that the original electronic file stays with the government agency.
Why do you care?
It's a great question.
I mean, other than the fact that you don't like this requester,
Sure.
why do you care?
So that's the policy question, right? It's sort of the elephant in the room. A couple issues. Number one, that sort of policy determination, and we heard it in the first argument, is really left for the legislature. This court's decision or jurisprudence has always said, whether the legislature included a right or not in a statute is for the court to interpret, but the policy decision-making behind it, whether it was good drafting or not, is not for the court to make.
But the policy under all of the attorney general opinions before Cora was enacted said that an electronic record is discoverable and should be given at the request of the requester, right?
After Cora was enacted, I think you meant
What?
to say.
Well, I think there were attorney general opinions even before Cora that it was the requester who gets to decide the format.
The oldest attorney general opinion and analyzing Cora was in 88, that's been cited by both parties, and Cora was enacted before 1988. But the policy, we don't have to guess about. We don't have to read the legislative tea leaves. The legislature in 45-216 expressly stated what the public policy is, and it's a right to inspection. It's not a right to copies even.
Okay.
The
well,
legislature was very clear about that.
But the attorney general consistently said it was the requester who gets to decide and even in letters to legislators, and they didn't change the statute. So isn't there a presumption that that was okey dokey with them, that they left that blank in the statute?
There's not. But as the court is well aware, attorney general opinions are at best persuasive authority. The court routinely dismisses them, especially when the logic and the legal analysis is faulty. All of those prior attorney general opinions are faulty legal analysis because they all imply the right into Cora. They say that they're implying it based on the public policy of a liberal interpretation. But liberal interpretation is a rule, a canon of statutory interpretation. It requires a prerequisite of ambiguity.
And
But
to
somebody-
that point, to that point, Mr. Templeton, everything you're basing on, is that there's an absence of language allowing the requester to dictate the format. And so there's no ambiguity. But isn't it also true that there's an absence of language allowing the agency to dictate the format?
There is, and for,
Wouldn't- So, so I don't understand if there's also that absence of language.
why we get the benefit.
Right.
Right. So that's based on this court's own jurisprudence. Data tree is the most recent example. There, the court was analyzing whether or not the requester paid for redactions or the government agency. And what the court did is it actually looked at FOIA, which Cora was in part modeled off of, and the Kentucky Open Records Act, both of which, Justice Wilson, you're correct, do contain rights of requesters to dictate the format they receive documents in. And in Data Tree said that FOIA puts the burden of redaction, the cost of redaction, onto the public agency. But because it's missing from Cora, and because the legislature is tasked with knowledge of those corollary statutes that they're using as influence for drafting our laws, its absence means the legislature intended to omit it. And
Right, but they went to statutory construction, which goes against your argument that it's the plain language, that we don't ever have, we have no ambiguity. And so we don't have to go to statutory construction or 216A, which requires liberal construction.
that's right. And that's in direct response to your question, Justice Standridge, that if its absence, what does its absence mean? That's trying to divine the legislative intent. Then we have to follow this court's jurisprudence as to its absence and the corollary statutes. But you're exactly right. At the outset, there's no language within Cora that implies or that expressly gives a requester's right to dictate the method that they
But
receive their
wh-
copies.
Why would it be logical if A, the person is entitled to the record, B, it is absolutely part of the record that the person is entitled to, C, that person has to pay for everything, including time of redaction, time that it takes to get the record. So D, why shouldn't the requester then logically be able to determine the format, since she has to pay for it, instead of the agency who may not like the requester and want to make it as expensive as possible?
Well, here, all of the records, I think the most expensive request she asked for was like $30, and none of them were paid for, including actual hard copies.
Did
that
you
she
ever
requested.
offer to give it to her in electronic format that you had available without adding anything to your records?
No, she was never offered the opportunity for an electronic format.
But that was what she asked for.
Well, not entirely. She did have a lot of requests that did ask for hard copies in addition to electronic version, and she never paid for those either.
I want to simplify this. There's an Excel file, just an Excel file, spreadsheet. And as I understand your argument, you want to say and that when that Excel file is requested, the agency has the discretion to decide not to just email the file to the person. It can print the file and hand over the paper, right?
Correct.
And so if you like the requester, you'll email it. And if you don't like the requester, you'll print it out because that's more burdensome to use the information.
No, I don't. That's where I disagree.
But you'd have that ability.
No, it would be based off the agency's policies and procedures, which the legislature has mandated that they enact.
Where is there a policy that says that they get to burden one requester and not burden another requester?
That presumes that they're going to produce the documents differently to different people. My point is that they have to follow their policy. So if their policy says we're going to produce electronic versions sometimes or all the time, they have to follow that policy. For example, this court's.
Was there that policy in existence prior to her request for those computer files?
The hospital's policy does not allow, it doesn't,
Is it written? Is
it's
that
a
a-
written policy.
Is that a given fact that you
Yes.
had this policy?
It's in the
question
record.
is whether that policy then violates the open records law.
Right, that could be the next analysis, but Phillips County's Cora policy mirrors in this respect, this court's own Cora policy, which the court has at Rule 160B, subsection B2, which this court has approved and says that when a requester asks for electronic documents that are not in a court docket, that the Cora officer has the discretion to determine the format in which they're going to produce those. It's the court's own policy.
What is?
Let me-
I'm sorry, go ahead.
I'm struggling with just this basic concept of what is a copy under your formulation of how you read. So, you know, as a copy, to be a true copy must contain everything and it must look the same. I mean, if you have, going back to your daughter's, was it Van Gogh, print, it's not a copy of a Van Gogh if the lily pads are in the sky rather than on the bond. So if you produce it in a format where the metadata is not embedded and available, but maybe over here it's a separate, you know, we're going to give you a separate sheet of paper that has the formula on it. Or we're going to say, oh, look here, and you know, A1, we've got this information. It's different. It is not a true copy. So isn't the only way to do a true copy of, let's say, an Excel spreadsheet to actually provide an Excel spreadsheet in
No,
electronic form?
no, with 2 keystrokes, you can produce an Excel file with all of the formulas printed in it. It's not
But now
hard.
you're creating a
But
new
you're-
document.
different
It's not, it is the document unless the data, as Justice Stiegel's pointing out, the data is not part of the document. In which case, I'm not sure why she's entitled to the Excel spreadsheet at all. It's not part of the open record, but
What I'm saying is you would, if you print it out and you may in some format provide that metadata, but if you've printed it out, you've changed the document, haven't you?
no, because Cora was enacted in the early 1980s. We were always making copies of government documents.
But those,
Always.
those documents, typed on a typewriter didn't have metadata. I
Right,
mean, you
right.
know,
And now we
uh,
do. And the legislature has never gone in to address the metadata
It
question.
didn't need to, did it? Because it said you will give a copy. And,
Of-
and if that document has within it that metadata, isn't that a copy of that necessary to be produced?
It doesn't require, if the information itself is what the requester needs, right? So we're making, like, let's go back to the typewriter example. We're making a physical copy of the typewriter, of the typewritten page. And so if there's a line through it and it's typed above, that is reproduced on the copy. If we're able to, excuse me, print the Excel spreadsheet, we're able to print it with the formulas. We're able to produce, just like in civil litigation and in criminal litigation with electronic discovery through 6234, and we're able to produce all of this information. And she has, or the requester has that information that's inside the record, then it is a direct copy. It's an absolute replica. Actually, a replica of an Excel spreadsheet is a printed one without the formulas, because you can't see the formulas unless you start digging into it. But at the end of the day, it's far simpler than that. The legislature has never allowed the requester, regardless of what a record is, regardless of what a record contains, has never allowed a requester to dictate the format that they receive the documents back in.
That gets me to the one, I'm sorry, did
Go
you?
ahead, go ahead.
That gets me to the one thing that's been bugging me a lot in reading all this material is you seem to argue that the agency benefits from silence statute. In other words, statute didn't tell you you have to do it, so therefore you don't have to do it. And that seems contrary to me to Stephan versus Harder. Because in that case, there were documents that commingled private data, confidential data with public expenditure of funds. And there was nothing in the law that existed at that time that said the agency had to redact the confidential part from the public expenditure part. And the court said the policy of this law is that the agency has to do that in order to promote disclosure and public, and public information. And so I don't think silence I don't see how silence as a matter of law helps the agency under this particular statutory scheme. So
Right.
what's your response to that?
Well, in this case, it is writing a right into the Cora that's not there, that the
Oh,
legislature. never-
Redaction. Redaction didn't exist in the law at the time Stephan versus, does
Right.
now,
Right,
because they codified it.
Right.
But it didn't then, and this court unanimously said that you have to do it in order to promote the policy behind open records law.
and I think the analysis in that case is that unredacted, the government information contained in the record is an open record. That information is obtainable. And so procedurally, the government agency can't just commingle data, government data with private information to bar people from accessing government documents. That makes sense. That makes logical sense. That really goes to the metadata question that is sort of kind of floating in the background of this case of, well, if we're going to go down the rabbit trail or the rabbit hole of metadata, where do we draw the line? What metadata is accessible?
Except that you're trying to use this silence, give you discretion to burden people who are asking for the disclosure of public information.
And
Regardless of whether you have a policy that existed before or after,
Right.
the policy you've enacted burdens the production process of the open records law.
burdens in
That's
the
contrary to public policy from the introductory statements in the statute. I don't see any difference there.
burdens them in the sense that they can't get it electronically, so it's
Yeah.
manipulable.
Yeah,
Is
so
that
they can, so that they can, or just be able to use it conveniently on their computer or have it quickly, because you only have to click a button and email it to them and you're done, instead of having to produce copies and then say, oh, well, there's 500 pages here of this spreadsheet, so you owe us 25 cents a page. That's what you're saying you get to do under this law.
Well,
And that seems contrary to public policy, as stated by the legislature.
again, on the public policy angle, the public policy is the legislature expressly limited to the right to inspection, not copies. 45-216 is limited expressly just to the right of inspection, the public policy of Kansas. But as to the burden argument, it's sort of the larger public policy question, right? Of what's the risk? Why not just give it to them? And the issue is, what else is inside that document? If we open up this opportunity for the requester to get that, what metadata gets sent? How does an
You get
agency?
to litigate that document by document. If you've got secret attorney-client editing inside of a Word file, all you have to do is say, hey, in version 6 of this document, there's a bunch of comments in here by a lawyer, and that's not disclosable. So this gets redacted, or it gets, whatever the remedy is. But you don't create a blanket exclusion on the possibility that there may be something else out there.
Not on the possibility, on the fact that there's something else out there. So for example, if the court adopts this broad rule that anytime someone asks for a public record, you have to produce it in its native format, then someone could request this court's Word version of its opinions and could look at who edited the document, who was the last person to edit the document. They could ask for prior versions of the document if it's already been if the opinion itself has been publicly published, then the draft exception would no longer apply in 221. And that gets us down a rabbit hole of things the legislature never considered.
Why is that a rabbit hole? I mean, isn't that exactly how the Open Records Act is supposed to work?
It's not.
You say, I want a public record. And then the public agency says, well, this public record is not disclosable for the following reasons.
But
Therefore, you don't get it.
there wouldn't be a basis to prevent disclosure of those draft opinions from the court. There wouldn't be an
Actually, I
exception under.
think that's a
Florida.
bad
Quite a few
example.
exceptions that would apply. but-
Right.
But there's an exception that swallows your.
Yeah.
your-
Well, the exception that the court is in charge of drafting its own rules. And that exception, the court has said, we have the discretion to determine what format we're going to produce public records.
Let me
in.
ask my question about this word format that keeps coming up. It strikes me that we've dramatically broadened that word. When I hear format, that the requester doesn't have a right to dictate the format. To me, what that says is you can't dictate that you get this electronic document on a thumb drive. If we want to email it to you, we can. If we want to burn it on a CD, we can. If we want to put it on a thumb drive or whatever electronic, then that's the format. But we're talking about the same record. But when you use the word format, you're talking about actually changing the record. And this gets back to, I know Justice Luker's question about what is a copy. Let me ask the question this way. If this court disagrees with you that a printed version of the Excel spreadsheet is a legitimate copy, do you lose this case?
If a printed version of an Excel spreadsheet
It-
is a copy?
Yeah, your argument is that I can print an Excel spreadsheet and I have made a faithful copy.
Mhm.
That's your argument. If we disagree with that argument, do
Mhm.
you lose?
No, I don't think so.
Well, why not?
Because the legislature didn't give the requester the right to dictate how they receive the document. So it still would be the discretion of the agency.
To do what?
To produce a copy.
And
And, but that raises the second question, right? Which really isn't briefed in front of the district court. There are no experts to opine on this, but is a PDF of the Excel document or the PowerPoint or
let's
the Word
say,
document.
let's say,
a
I'll make
copy.
this as easy as I can. Let's say this court concludes, and this is hypothetical,
Sure.
that to make a correct, a true and faithful copy, it has to be a copy of the electronic document in electronic. form.
In
do-
its native, like Excel
Well,
to
it's just a
Excel.
copy. It's a, you click and drag. I
Right,
want to make
right.
this as simple as possible.
Right.
If that's what copy means, do you lose this case?
Yes.
Okay.
Yes, to make sure that I'm answering the right question, that if the court holds that a copy of an Excel document means it has to be given to the requester in Excel, yes, we lose. Yes. Thank you.
I know you've got a lot to chew on there, but I want to follow up just. Can our opinion simply be limited to that Excel file is a record under the law and leave it for you all to fight about what's in the record?
I believe so, Your Honor.
Is there any other, I know this is the one on interlocutory appeal, I think. Is there anything else in the case we need to decide other than that Excel file is actually a record? And so it is subject to disclosure under the law, under the open records law, and then you're into whether all the exceptions apply and all that business.
Yes, that's the position of my client, is that we are asking for a determination that in this example, the Excel spreadsheet is the record that must be disclosed.
The file. I mean,
Yeah, the file, yes.
whole thing that,
The .dox or
Yeah.
whatever,
Yeah.
yes. Right. Other than that, Your Honor, I just want, as I just have a few seconds, I'll just comment on one thing. There was some suggestion that the Open Records Act is only about inspection and not copies. Well, that of course would just totally dismiss each and every aspect of the law that goes through copies and all the procedures for how to get copies, and then the presumption of access that has the tradition of access that has been effectuated over these decades. And I would also just lastly say that even though the Open Records Act was enacted in the early 80s, these Attorney General opinions talk about the dissemination of electronic records, very early on. So the core is not limited to paper records. It was never limited to paper records. The definition of open records requires the disclosure of the file that the record exists in, for example, an Excel spreadsheet.
So is the word copies then ambiguous?
Absolutely. The word copies is ambiguous, and to the extent that it is, then that requires the statutory construction, which brings liberal construction into play.
Why are you saying it's ambiguous?
Well, the word copies is not defined, and every time the word, I guess that I'm just being deferential to the Court of Appeals.
and the definition of ambiguity, which is, allows for different interpretations. I think that the definition of copies, for kind of the reasons that you all suggested in the questioning, copies has become a loaded term. Are copies electronic? Are they paper? So I do think it's ambiguous, but I also don't think that any of that really matters. What matters is not so much the word copies, but the word public record, and whether or not the Excel spreadsheet in this case falls into that definition. It does, and therefore it should be disclosed. Thank you.
Thank you to both counsel for your arguments in this matter. We will take this appeal under advisement. We will be in recess now for 15 minutes. We'll resume court at 11. All right.